Hello, I'm Dan Marr from Hamlin Kerrigan in Nashua, New Hampshire, and I've been practicing for over 35 years. I'm licensed both New Hampshire and Massachusetts, and part of my practice includes trust and estate litigation. And in this blog today, I'm going to be talking about breach of fiduciary duty as a trustee. So when you're considering being a trustee of a trust, perhaps your parents went in, decided that you're probably the best situated of the siblings to be the trustee of all of them, or maybe there's minor children involved, but maybe the trust goes on beyond their death. It's not what's called a revocable trust. It goes on beyond their death, and they have you as a trustee. You don't have to accept that. You can consider whether you want to accept it, and one of the things you want to really consider is, do you have some animosity towards some of the beneficiaries? Or do you think that they may think that you have animosity towards them? Because as a fiduciary, you have an obligation to them. You have an obligation to keep with the trust's intent as well, but you have an obligation to them. And I've been involved in cases, including picked by the court after trustees were removed for that very issue of breach of fiduciary duties. And I've continued on, and we've actually went forward with some prosecutions or legal claims, civil legal claims against the former trustees for that, and I've also dealt with that as a lawyer on behalf of clients in regards to that. So when you're dealing with a breach of fiduciary duty issue, the issue comes down to, did the trustee do something in self-interest? Did they do something in conflict with their fiduciary obligations, meaning that they were not following the intent of the trust, and whether or not they were following their own self-interest, or just maybe animosity towards the beneficiaries. I've certainly had a case, I actually had a case where the trustee was a brother of his sibling brother. Frankly, did a very good job with the investments on the situation in the trust when he was dealing with the trust after his parents' death. But he did it in such a way to hurt his beneficiary brother from getting the trust proceeds, because it was a condition that was supposed to happen, and he made sure that there never was going to be enough money there for this person to meet that condition. And even though they did very well with what he did in this situation, he did a lot of growth stocks, so he was building up the trust corpus, but he wasn't providing income to the beneficiary. He was doing that really out of animosity towards his brother. Bad situation, breach of fiduciary duty. Even though he was doing a very good job and competently investing, he was still breaching his fiduciary duties to his brother, who was a fiduciary. I've also had situations where in irrevocable trusts, there's something called decanting, where somebody, there's limits in this in New Hampshire law, and it's defined now because of the case that I was involved in as a trustee, replacement trustee. There's a couple of cases, the Hodges case, Hodges 1 and 2, you'll see in the New Hampshire Supreme Court, deals with this, but you can't go and there's limitations on your ability as a trustee to change the irrevocable trust, because an irrevocable trust is supposed to be irrevocable, unlike a revocable trust, which is a normal estate planning tool. So when you're considering that, all of those issues, that's part of your fiduciary obligations, to not only follow the intent of the trust, but follow trust law, and then also treat the beneficiaries as somebody that you're supposed to be caring for. You have a fiduciary obligation, you have a duty of loyalty and trust, and trying to benefit them, all within the parameters of whatever the trust agreement says. But changing that trust agreement, if it's an irrevocable trust agreement, because the grantor decides later on to change his mind, but it's irrevocable, there's limits to that. There's these limits on decanting. Decanting can happen, but there's protocols, and you can't change your estate plan basically when you have an irrevocable trust. That's for tax purposes, it's for Medicaid planning, all those things. The reason for an irrevocable trust is it has to have some irrevocability to it. So you have to follow that, you have to follow the trust law. So if you're thinking about that issue of becoming a trustee, make sure you can meet those obligations. If I'm representing a beneficiary and I see somebody that is, or if I'm representing a trustee, I'm going to be giving the same similar advice in here. If I'm representing a beneficiary, if there's animosity, there's self-interest or the like, we may do everything from little as trying to remove that trustee to going after them for damages if they actually cause damage to the client. So be careful about that. You might be stepping yourself into personal liability if you become a trustee and you can't meet those obligations. And for beneficiaries, if you're in a situation where you think that the trustee is acting out of their own personal animus towards you, or self-dealing, or anything like that, and they're hurting you, you can contact myself. I can, assuming there's no conflicts, we can discuss it. I'd be willing to have a discussion with you. My number is 603-883-5501. That's 603-883-5501 at Hamlin and Kerrigan in Nashua, New Hampshire. I do trust and estate litigation and licensed in both New Hampshire and Massachusetts. So happy to discuss this with you. Or you can check out our website at NashuaLaw.com. That's www.nashualaw.com, and you can check out our website. We have these vlogs there. We have a lot of other very useful information. So I look forward to the opportunity to work with you if the opportunity so arises. Thank you.